What this means to you is that, generally, if you had experienced any personal injuries connected to the closings during what had been described by Attorney General Mark Herring as the once-in-a-century pandemic, characterized as threatening irreparable harm to an unknown and unknowable number of people, you had only 2 years to bring your case for personal injuries, and, coincidentally, in the longest respiratory tract infection pandemic in history, the pandemic emergency was not terminated until May 11, 2023, and the statute of any associated personal injuries arising therefrom has probably already told, making it a truly novel coronavirus to have taken advantage of that little loophole, and, as CDC Director Rochelle Walensky, MD had said, this virus isn't stupid. However, had that case been brought, while defending the government response to the global public health crisis, Attorney General Mark Herring takes credit for persuading the courts that, even if traditionally courts issue speculative damages, the pandemic emergency had warranted deferential treatment to the government regulators, so that the scope of a court's review must be limited to a determination of whether the executive's actions were taken in good faith and whether there is some factual basis for the governor's decision that the restrictions he imposed were necessary to maintain order. However, under the rule stated in Dunlap v. Cotman Transmission Systems, LLC, an action for injury to property and rights is subject to a 5-year statute of limitations, at least for purposes of the business conspiracy statute. And, under Virginia Code Section 8.01 to 230, in every action for which a limitation period is prescribed, the right of action shall be deemed to accrue and the prescribed limitation period shall begin to run from the date the injury is sustained in the case of injury to the person or damage to property, and not when the resulting damage is discovered, except where the relief sought is solely equitable or where otherwise provided under law. Applying this rule, if you had not discovered that the executive's actions were not taken in good faith and whether there is not some factual basis for the governor's decision that the restrictions he imposed were necessary to maintain order, until 5 years after June 20, 2020, when he had closed all public schools to in-person instruction, your claim would be barred by the statute of limitations, and you and your child would be, as they say, SOL, with the same rule applying to masking or even vaccine mandates. You snooze and you lose. It's like a law. However, your legislators, recognizing as Chief Justice Warren had in the landmark decision, Brown v. Board of Education for Topeka, Kansas had, that today, education is perhaps the most important function of state and local government, had changed the statute of limitations for actions taken by a school board. As the Virginia Teachers Union says, what's good for the teachers is ultimately good for the kids, and under Virginia Code Section 22.1-87, any parent, custodian, or legal guardian of a pupil attending the public schools in a school division who is aggrieved by an action of the school board may, within 30 days after such action, petition the circuit court having jurisdiction in the school division to review the action of the school board, which statute of limitations had told long before now on the COVID-19 response at the Arlington public schools. Under the controlling law, had that judicial review occurred, it would proceed upon the petition, the minutes of the meeting at which the school board's action was taken, the orders, if any, of the school board, an attested copy of the transcript, if any, of any hearing before the school board, and any other evidence found relevant to the issues on appeal by the court, and the action of the school board shall be sustained unless the school board exceeded its authority, acted arbitrarily or capriciously, or abused its discretion. While suits had been brought about the closing of businesses, and even some places of worship, not constricted by a brief 30-day statute of limitations, not even one lawsuit was brought in the entire Commonwealth of Virginia regarding the closure of public schools to in-person instruction. Not by one parent. Not by one guardian. And not by one custodian of any pupil, not even in Arlington Public Schools, the second best public school division in the entire state, which had, in 2020, almost 30,000 students in grades from K to 12, and that's a lot of parents. Nor did any educator or employees or the teachers' union bring a case. And so, had your child been injured by the closure of public schools, it is safe to say that your child is just SOL, barred from recovery under the statute of limitations for any personal injuries for certain, while anyone claiming a derogation of any civil right, as claimed to be possessed by Chief Justice Warren, who said, such an opportunity, where the state has undertaken to provide it, is a right which must be made available to all on equal terms. Your time is running out, at least in any civil action. However, during the tumultuous times associated with the civil rights movement, the Fourth Circuit in Richmond had recognized in US v. Chalk that all power may be abused if placed in unworthy hands, and that, while the courts cannot prevent abuse of power, but can sometimes correct it. Hence, as any fan of unsolved crime stories knows, there is no statute of limitations on criminal conduct, and, of record, even though Edgar Ray Killen was still convinced in 2005 that no jury in Mississippi would have convicted him of murdering Freedom Riders in 1964, the Mississippi Supreme Court politely informed him that he should have gotten convicted then to bar prosecution under prohibitions against double jeopardy.
And, as stated by the Virginia State Supreme Court in Goodman v. Commonwealth in 1930, while the kind of negligence required to impose criminal liability has been described in different terms, it is uniformly held that it must be shown that a homicide was not improbable under the facts as they existed, which should reasonably have influenced the conduct of the accused. The negligence must not be so gross as to raise the presumption of malice. It must have been the negligence of the defendant personally, and it must be the proximate cause of the homicide.
As stated in Davis v. Commonwealth by the Virginia State Supreme Court in 1985, to constitute criminal negligence essential to a conviction of involuntary manslaughter, an accused's conduct must be of such reckless, wanton or flagrant nature as to indicate a callous disregard for human life and of the probable consequences of the act. As stated by the U.S. Supreme Court, in the matter in re Winship in 1970, the Due Process Clause protects the accused against conviction except upon proof beyond a reasonable doubt of every fact necessary to constitute the crime with which he is charged.
As stated by the Virginia State Supreme Court in Powers v. Commonwealth in 1970, it is elementary that the burden is on the Commonwealth to prove every essential element of the offense beyond a reasonable doubt. And as stated in Savage v. Commonwealth by the Virginia State Supreme Court in 1888, in a criminal case, the defendant is entitled to an acquittal unless his guilt is established beyond a reasonable doubt.
Thus, the issue is whether the trial judge could have found beyond a reasonable doubt that the school board, in reckless disregard of the rights of others, had created a situation that they knew or should have known it not improbable that serious injury would be occasioned. You say you love your kid, but, post-pandemic, the question may be, how much do you really love your kid, who you placed in free, public school that closed for 2 years while you did nothing? Right?
This message was approved by Major Mike Webb. Honest.
And y'all go back now. Yeah.